Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with and what your rights are concerning your case. The case that you have in this court is classified as a misdemeanor case. It's a criminal case, and the criminal cases are divided into two categories, divided into felonies or misdemeanors. The felony cases are referred to as your more serious type offenses, and that just simply means that, and when I use the term serious, I'm talking about the facts and the punishment that a person can get. Your misdemeanors are referred to as petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, your felony offenses, we have 5 classes of felony offenses. We'll start at the top and work our way on to the bottom. You have the capital murder, the first degree felony, the second degree felony, the third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is the capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal ejection. Now, as I mentioned earlier, the case that you have is a misdemeanor case, so you don't have to worry about those type punishments. Now, misdemeanors are divided into 3 classes. We'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanor, the range of punishment for Class C misdemeanor is a fine that does not exceed $500. So you cannot be given jail time. You only could be given a fine up to $500. Now, the misdemeanor cases are cases that are handled in the Justice of the Peace Court or the municipal court. They come to this court when they appeal their conviction in the JP court or the municipal court. Now, the punishment range does not change. It's still the same, maximum $500 or less. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to maximum 180 days in the county jail or a fine that does not exceed $2,000, or you could be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to maximum 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation means that you will not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for what is called a non-disclosure. A non-disclosure means that we, talking about the state or the government, we cannot disclose the fact that you were on deferred adjudication to the general public. So we can't tell the general public that you were on deferred adjudications. It's like having your record sealed to the general public. However, The government can't have access because they're not considered as part of the general public. So governmental agencies, governmental organizations, they will have access to that record. But most of the public is the general public. And so they will not have access to the fact that you were on deferred adjudication or unadjudicated probation for your charge. The next type of probation is called adjudicated probation. Adjudicated probation, with adjudicated probation, we call it regular probation. You will have a conviction on your record. However, there is something that is called judicial clemency. Judicial clemency means that the court or the judge can set aside your conviction. In order for that to happen, there are one of three things. Well, three things has to occur first before the judge can have the discretion to set aside your conviction. First, you need to complete the probation. Second, there cannot be any more time left on the probation. And then third, you have to be successfully discharged from the probation. If those three things happen, the court has the discretion to set aside your conviction. And if the court set aside your conviction, that simply means you will no longer have a conviction on your record for this charge. However, if you get a subsequent conviction, that is, if you get a conviction later on, another conviction later on, then this case can be resurrected, revived, or brought back up and used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend the license that you have. As a defendant in a criminal case, you have rights. Now, the first right that I'm going to go over is your right to have an attorney. Now, the clipboard that you have talks about your right to have an attorney. As a defendant in a criminal case, you have three options. And that's on Judge's Explanation of Rights to Defendants Without Attorney. That's what the title of that form is. Now, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you can ask for an attorney to be appointed to represent you. Or number three, you may represent yourself. Now, you can represent yourself if you waive your right to an attorney, which means if you give up your right to have an attorney to represent you, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means that you will be given another court date from this court date to give you time to hire your attorney. If you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Now, in order for that to happen, you have to first fill out a financial questionnaire. The financial questionnaire is the document on that clipboard that is titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page of that form and half of the second page of that form. And then the proper person will determine whether or not to appoint an attorney to represent you. If you want to represent yourself, that is, if you want to waive or give up your right to have an attorney and you would like to represent yourself, then you will have an opportunity to talk to one of the prosecutors in court. The prosecutors, they are assistant criminal district attorneys that works for the district attorney. And you can talk to them about your case to see if y'all can settle your case or work out an agreement on your case. Now, before you're able to do that, you have to first sign a written waiver of your right to have an attorney. Now, so you'll be waiving your right or giving up your right to have an attorney. That document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That should be the second document on that clipboard. Now, you should be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to waive your right to have an attorney, or if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of the document that is titled Judge's Explanation of Rights of Defendants Without an Attorney, it states, defendant's choice, mark initials next to only one choice. That's in bold letters. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If your choice, well, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request or ask for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to have an attorney to represent you or give up your right to have an attorney to represent you and you desire to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, May 7th of 2024, on the line that is titled date. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and you would like to represent yourself, you will have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. That's only for individuals who will be waiving their right to an attorney and representing themselves. And I'm going to go over this document with you, and it states as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 7th day of May 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date. Now, as a defendant in a criminal case, you also have other rights. One other right that you have is a right to have a trial by jury. Where those 12 chairs are, we call that the jury box. 6 citizens from Jefferson County will be selected to sit as jurors in your case. They will listen to all of the evidence. They will listen to the arguments of counsels. They will deliberate. And then after they finish deliberating, they will decide to find you not guilty or guilty of your charges. Now, you also have a right to waive your right to have a trial by jury or give up your right to have a trial by jury. That simply means that you will not be having a trial by jury. If you waive your right to have a trial by jury, then your case will come before the court or before the judge in one of 3 ways. One way it will come before the judge is by way of a trial without a jury. It's a trial before the judge only. The judge will be the judge and the jury in the case. We call that a bench trial. The judge will listen to the evidence. The judge will listen to the arguments, and then the judge will decide whether or not you're guilty or innocent after the judge applied the facts to the law. Now, you also have a right to waive your right to have a bench trial. And if you waive your right to have a bench trial and you still want, and your case will come before the court, you're not having a trial by jury, you're not having a bench trial, a trial by judge only, then your case will come before the court by way of a plea. And that's PLEA. And a plea basically means that if you have, that means that you are entering a plea of either guilty or no contest to your charges. Now, you can enter one of three types of pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. So if you waive your right to a jury trial, you waive your right to a bench trial, your case will come before the judge by way of a plea bargain. That is, you enter the plea of either guilty or no contest to the charges. And there are two types of pleas. One type is called an agreed plea bargain agreement. That means that you in the state of Texas have reached an agreement to settle your case. The other type is called an unagreed plea bargain agreement. That means you in the state has not agreed to settle your case, but you would still like the judge to assess the punishment. Okay? So if you have an unagreed plea bargain agreement, you and the state have not been able to reach an agreement, your case comes before the judge will assess the punishment within the punishment range. Now, if you reach a plea bargain agreement with the state to settle your case, then your case will come before the judge. The judge can do one of two things. It can accept or reject the plea bargain agreement. Okay? If the court accepts the plea bargain agreement and you decide within 30 days that you would like to appeal your case, that is, you like to have a higher court to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you, then if you would like to appeal your case, if the judge follows the plea bargain agreement, you have to get the judge permission to appeal your case to a higher court. And if the judge gives you permission to appeal your case will go from this court up to the Ninth Court of Appeals, which is located right above us on the third floor. They will review your case, and they can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, well, you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas, and you would have to file what is called a pro se petition for discretionary review. And what that means is pro se means that you will be representing yourself. You want to have a lawyer, you'll be representing yourself, and then you'll be petitioning them or asking them to review your case to see whether or not the Ninth Court of Appeals should have granted your appeal, or whether or not you were wrongfully convicted or this court committed an error by convicting you. They can do one of two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or if they deny it, they can order that this case goes back to the Ninth Court of Appeals for further orders, or they can be sent down to this court to give you a whole new trial, or they could, well, it could be sent down to this court. They can order that we give you a whole new trial, or they can, if they order that we give you a whole new trial, then we have to follow the order that they make. Okay. Now, the other thing is, if they deny your pro se petition for discretionary review, then your conviction will stand. Okay. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. If you have a jury trial, if you want witnesses in your case, you have a right to call witnesses. And what witnesses do, they can testify for you or against you. If you have an attorney or if you represent yourself, you can ask them questions, or your attorney can ask them questions. We call it either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses. Waiving or giving up your right to have witnesses means that you will not be calling witnesses. It does not mean that the state or the district attorney's office will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have a right, a Fifth Amendment right against self-incrimination. That is, you have a right not to testify in your case. The district attorney's office, the state of Texas, the government cannot force you to testify in your case if you exercise your Fifth Amendment right. In essence, if you say, well, I take the Fifth, or I'm not going to testify in my case, they cannot force you to testify in your case against yourself. Now, you can waive your Fifth Amendment right against self-incrimination. That is, give up your Fifth Amendment right against self-incrimination. If you do so, you will be testifying in your case. Now, you also have a right to have discovery. And what discovery means, you have a right to see the evidence that the state will be using against you. You have a right to have access to it. In essence, you have a right to discover what the state has. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings. You have a right to have access to the instruments or anything that they have that they will be using as evidence in your case. You have a right to have access to that. Now, you have a right to also waive or give up your right to have discovery, which means you're saying, I don't want to see it. I don't want to have access to it. You have a right to do that. Now, everyone that's here for this case or for your case, you've been arrested and you bonded out of jail. You get out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay any cash to get out of jail to anyone. However, you were released under your personal recognizance with a promise to appear here in court. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. And you notice that I said every day. If you spend 1 minute in jail, that's considered a day. Okay? Now, let's say you were arrested and you was booked in jail at 11:59 p.m., 1 minute before 12 midnight, right? And you got out 2 minutes later at 12:01 a.m. That's considered 2 days that you spent in jail. There's 2 different days, okay? And so every day that you spent in jail can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail. You and the state has reached a plea bargain agreement, and the agreement is for you to serve 5 days in jail. That simply means that you will not have to serve any more time in the jail on this case. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they are offering in the plea bargain agreement 7 days in jail and you serve 5 days in jail, we take the 5 from 7, that leaves 2. You would only have to serve 2 days in jail. Now, every day in jail, every day that you spent in jail can also be used as credit towards your fine and court costs. So every day that you spent in jail, you will be credited at $100 per day that will go towards your fine and court costs. So if you spent 5 days in jail, that's $500 that can go towards your fine and court costs. So if you're in the state of reach a plea bargain agreement for you to pay fine and court costs of $500, you will not have to pay anything. Why? Because the 5 days you spent in jail has already paid it off. Therefore, the $500 fine and court costs will be taxed and retired. Now, if they're offering fine and court costs of $700, that simply means that you'd have to pay $200 more. Now, because we'll take 500 from the 700, that leaves 200. Now, you'll be required to pay the 200 on the day that you enter your plea. If you cannot pay the $200, on that day. We can put you on a payment plan. That means that you can be ordered to pay off your fine and court costs in monthly installments until the balance is paid off. Now, if you are unable to pay off the balance, that's not a problem, because if you don't have the income to pay the remaining balance, that's not a problem, because we can convert the fine and court costs to community service. And you will receive $12.50 that will be credited toward your fine and court costs. So for example, if you owe $200, if you work 8 hours in a day, that's $100 that day that will go toward your fine and court costs. So if you work 2 8-hour days, that's $200 that will pay off the balance of your fine and court costs if you owe $200. Okay. Now, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. And what they will do, they'll dismiss your case and you can get it wiped off your record. In order to qualify for the program, it has to be your first time getting into trouble. That's one. And then two, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. Or three, you have to have an attorney to assist you with making the application to apply for pretrial diversion. So if you get into the program, again, the case is dismissed. If you successfully complete the program, you can get the case expunged from your record. Expunged meaning wiped off, deleted, or erased from your criminal record, like it never happened. So, like I say, you have a record today, you go through the criminal, you go through this process, and you don't have it on your record anymore. Okay? Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has another program that is called Veterans Court. It's a program for veterans only. And with that program, you will get into the program, and once you complete the program, they will dismiss your case, and you may qualify for a non-disclosure. Non-disclosure means that we cannot disclose it to the general public. And that's your record is sealed. All right. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017. And with this program is designed to address the issue of recidivism. Recidivism means when people commit crimes over and over. And so how do we address that? Well, we address it through our Community Safety Initiative. And with that program, we have partnerships with various agencies and organizations in our Golden Triangle area. And one of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center. And with Spindletop have the ability to do what we call they can do private interviews either in our jury room at their facility or over the phone, whichever is convenient for you. They also have the ability to do an assessment, and they can develop a treatment plan for you, either outpatient or inpatient services. Now, in order to qualify for the program, you do not have to be insane or incompetent. You can merely suffer from depression or anxiety or any other host of mental illnesses, and they will be able to address those issues that you have. If you have issues with drugs or alcohol, well, Spindletop has a program that is called ATAR, and our local alcohol and drug council has a program that is called OZAR. Now, ATAR stands for Addiction Treatment and Recovery. OZAR stands for Outreach, Screening, and Assessment and Referral. Those programs are alcohol and drug recovery programs. They will do private screenings and assessment, and they can develop a treatment plan for either outpatient or inpatient treatment as well, depending on what your needs are. If you are unemployed or if you're looking for a better job, we have a partnership in the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that you select, then they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get your high school diploma, well, CICE also has a GED program. GED stands for Graduate Equivalency Diploma. You can get your GED. That door is locked, so you got to go through the other door. And so you can get your GED with the CICE program. Now, all of these programs that I just mentioned to you will not cost you anything because they are free. It won't cost you anything but time. And in this court, I like to say we don't just give time, we take our time. That simply means we don't just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I say that when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference. And we believe that if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so with this program has been able to change lives of individuals, change family lives, change communities. And so if you're interested in these programs, just let us know, and we'll be happy to get you involved in the program. The other thing is this: all of these programs that I just mentioned can be used as community service. So for example, let's say you had to pay a fine, but you didn't have enough money to pay the fine. We converted the fine to community service. And let's say as part of your community service, you were getting your GED, or you were getting job training, or you were getting treatment for drug and alcohol abuse, or you was getting treatment for your mental health issues. Every 1 hour that you spend in treatment, either for mental health, drug and alcohol, or every 1 hour that you spend in class, learning a job or getting your GED, $12.50 is going toward the payment of your fine and court costs. And 1 hour is going toward community service, and you're in the program. And so I like to say that in this situation, you're not killing 2 birds with 1 stone, you're killing 3 birds with 1 stone. Why? Because you're in the program, you are getting your community service hours, and you're paying your fine and court costs all at the same time, just for getting the treatment that you need, getting the education that you need, getting the job training that you need. And so with these programs, as I mentioned earlier, they are free. And if you would like to get involved in any one of these programs, just let us know. And we'll be happy to direct you to the right person so that you can get into the program. Now, as I mentioned earlier, we have some individuals from Spindletop, as Danny and Deputy Hinton. They're going to come to you and tell you a little bit more about the program that Spindletop has to offer. Okay, Deputy Hinton and Danny.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state, Michigan here with Sheriff's Office. This is my coworker, Danny. Now, Danny is qualified mental health Spindletop. The reason we are both here today in this courtroom is because the judge cares about every single person who comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation. Now, maybe this is your first time to be in court, maybe it's your 10th time to be in court, there's still hope. In fact, what we're gonna offer you today has the ability to change your life, but we're gonna need something from you. If you look on that clipboard, we have this document, it's already there. It's a form created to be HIPAA regulated, which is controlled, your information is private, will not get shared outside the commission. But that's an opportunity for you to privately share with us what your need would be, as resources or whatever it is, however we can advocate for you. And we'll pick up that shortly. Also have a flyer here that I want to give everyone before you leave here today. On the back, it tells you some of the advantages of actually participating in the program. But on the front, it also has 1-800 numbers. Should you ever find yourself in an unsafe place, you can call the number and help you. And just shortly, the court's going to go into recess. When it does, we'll be able to come out there. We'll visit with you. We'll pick up this document from you as well, and I'll be handing out this form to you at that time. And we'll be able to answer any questions if anyone wants to speak privately. We'll also have the ability to speak in the jury room privately outside the trial. So if this is something that you see a value in and you want to learn more about it, we'll be glad to do that. Thank you, Your Honor.
Okay, you're welcome. Step in here. Yeah. Okay, ladies and gentlemen, before we go into recess, I need to give you some instructions. The paperwork that you have on the clipboard, we're going to pick that up. If you need any help with that paperwork, we're going to have our court personnel who's here who will be able to help you with the paperwork. And once we pick the paperwork up from you, we're going to ask, once we evaluate it, we're going to ask that you come up before the bench one at a time. And then now this is going to take a little time for us to go through everything that we need to go through. If you need to use the restroom, there's some restrooms right out in the hall. The female restroom is in front of county court at law number 3. And the male restroom is in front of county court at law number 3. The female restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you can use the restrooms and you come back in here. Now, do not leave the courthouse, because if you leave the courthouse and if your name is called and you're not here, your bond can be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. And if a warrant is issued for your arrest, you'll be arrested, placed in the Jefferson County Jail. Now, as I mentioned earlier, this is going to take a little time for us to go through the paperwork. And if you need any help filling out that paperwork, just let us know. You just raise your hand and our court personnel will be available to assist you at filling out the paperwork. Okay, so at this time, the court will be in recess. Mr. Bro?
Yes, sir.
what we're going to do is pursuant to Article 1.24 Texas Code of Criminal Procedure, all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State 365, Southwest 321, the right to public trial is not absolute. It may be outweighed by other competing interests, such as the interest in security, the publishing of non-public or disclosing non-public information, and that the defendant receives a fair trial. I think that at this time, we may get into a little non-public information that will be disclosed. And of the abundance of caution, Mr. Grove, would you like this hearing just closed to the public?
Yes, Your Honor.
Okay, so at this time, the hearing will be closed to the public. The party that's seeking a closure has advanced an overriding interest that is likely to be prejudicial to his client. The request is no broader than necessary to protect those interests, and the court has considered other reasonable alternatives, and at this time, this portion of the hearing will be closed to the public, and at this time, I will